In this video, we're going to look at voting restrictions after the Supreme Court's Shelby decision. We recall our electoral dynamics, where we've got a competitive district that involves a red candidate and a blue candidate. In order to win, you need to capture the median voter, the one in the middle, just over 50% of the electorate. Now, in this context, you've got a couple choices. You could run a campaign and maybe lose. However, if you happen to be the government in power at the time, you could try and manipulate the franchise. You could try and skew the electorate in your favor by imposing restrictions on the franchise. You could pass a law, for example, that restricts eligibility, targeting your opponent's supporters. So, for example, if the red candidate controlled government, they might target voters on the extreme left. They might pass a law that removes them from the electorate or makes it more difficult for them to register. What that does is it essentially moves the median voter. The median voter is now more accessible to the red candidate because they have removed some of the potential voters targeted by the blue candidate. This is actually a common strategy that was used throughout the American South. Historically, these types of measures and restrictions were very common, targeting black voters in the South. Now, Congress in 1965 passed the Voting Rights Act to try and stop this. Typically, states were using things like poll taxes, barriers to registration, literacy tests. There was a number of different measures. The Voting Rights Act tried to eliminate those. It prohibited states from using qualification strategies that resulted in the denial or abridgment of the right to vote based on color or other minority status. They also added a pre-clearance stipulation, and what that meant was that if any state, typically in the South among a select group of states, wanted to change their voting rules, they needed to ask permission from Congress first. They need to get those laws and those changes pre-cleared before they implemented them. Well, in 2013, a North Carolina county, Shelby County, challenged the pre-clearance stipulation. They suggested it was unfair because it was treating some states differently than others, and that was unconstitutional. The Supreme Court agreed. They struck down this provision of the Voting Rights Act. Chief Justice Roberts wrote the opinion saying the pre-clearance requirement was indeed unconstitutional. His reasons were that it's 40 years old, no longer responsive to current needs. Therefore, it was an impermissible burden on the constitutional principles of federalism and equal sovereignty of the states. Now, in his decision, he offered some evidence as support. The gap between white and black voters in 1965 compared to 40 years of the Voting Rights Act being enforced. And his argument was, see, we don't need it anymore. There is no gap anymore. There's no more discrimination. Clearly, it has worked. Now, the dissent, there was a dissenting opinion. This was a 5-4 decision. It was a very close decision at the Supreme Court. And the dissent wrote an opinion authored by Justice Ginsburg, said, yes, you're right, the data has changed, but it's because of pre-clearance that the data is changed. Throwing this out when it's working is like throwing away your umbrella in a rainstorm because you're not getting wet. And this was a very controversial decision at the time, and almost immediately states responded. Texas, for example, within hours, reduced the number of acceptable voting IDs that were allowed. And so in Texas, they have voter ID laws that allow you to vote with different pieces of ID. They shrunk that list of acceptable IDs, which resulted in, according to the Brennan Center for Justice, 600,000 voters in Texas that were no longer eligible to vote. And so that was a big change in a state where, for example, in the 2018 Senate election, it was under 200,000 votes that separated the winning candidate from the losing candidate. So this is a state where elections are close, and by taking a big chunk of the electorate out, it was potentially giving one party an advantage. Alabama did something similar. In 2014, they passed a new law requiring voter ID, special government issued voter ID, typically a driver's license. The following year, they closed 31 offices that issued driver's licenses. So that left almost 30 counties with no means of accessing this ID that they needed to vote. Again, big burden on some voters. North Carolina also within months passed new, very restrictive voting measures, strict photo ID requirements, limits on early voting. They eliminated same-day registration. They ended the ability of third-party groups to hold voter registration drives and to get people registered to vote. And they also reduced the ability, they eliminated the ability of local precincts to extend their polling hours. One thing that's common in the South is long lineups. And so typically if the poll's about to close and there's a long lineup, they allow local officials to keep the poll open for an hour longer to allow everybody the opportunity to vote. This law took away that ability. So just to recap, historically, voting restrictions have been very common in the American South. The 1965 Voting Rights Act tried to stop that by implementing a pre-clearance provision. However, in the 2013 Shelby decision, the Supreme Court said we can't do that anymore. That's unconstitutional. And almost immediately, post-Shelby, many states worked very hard to implement new voting restrictions.